My name's Pedro Alejandro Gonzalez, but I'm known as Peter or Pete Gonzalez. Before I get into a little bit about why Miami is a great venue for litigation, you've heard a lot about corruption in Latin America. We heard Guilherme and Francisco talk about the prior administrations in Brazil with Lula and Kirchner in Argentina. We all know what's happened to Venezuela with Chavez and then Maduro. And part of the disaster of that political instability and the economic ramifications are the benefit of folks like us in Miami. When things go bad in Latin America, a lot of people that have assets, that have money, that have kids, they want to send their kids to study somewhere where they don't have to worry about their kids being kidnapped, where they don't have to worry about the crime, the corruption. And we end up getting an influx of a brain drain, if you will, smart corporate individuals, entrepreneurs, people that want to put their money in a safer, more stable environment. So a lot of them end up in Miami. And that's part of the reason Miami is a little different than the rest of the country when there's real estate issues all over the world or in the US. Miami sometimes is a little immune because you have a lot of investors that come and put their money in Miami. And Pablo touched a little bit about the corporate transactional part of the practice that we have here at SMGQ in Miami. I want to talk a little bit about arbitration and litigation and why you should look to structure deals in your countries where you can bring any possible disputes to be arbitrated by private arbitration or litigated by state or federal judges in South Florida. And many of you have already done that, and it's a growing industry here in Miami. More and more arbitration is taking place in South Florida. As a matter of fact, according to most of the literature on this topic, Miami ranks, South Florida ranks either 3 or 5 in terms of the most international arbitrations that take place in the United States of America. We have 125 state court circuit judges in South Florida. Circuit judges are judges that deal with disputes that are from $15,000 into the billions of dollars. We have 39 federal judges, senior judges, and magistrate judges in the federal judiciary. The good news about judges in Florida and across the United States is that typically they're competent, ethical, decent human beings that actually rule based on the facts and on the law. And I say that because, as many of you know, in some of these countries in Latin America, that's not always true. I've personally had litigation matters in Mexico, in Ecuador, in Panama, Argentina, Paraguay, Venezuela, and Brazil. And the only country where I personally didn't experience some level of either corruption or unethical conduct or just blatant, suggestions that we bribe either a prosecutor or a judge was in Argentina. And maybe I just got lucky. But the matter I had in Argentina was straightforward and the courts ruled on the facts and the law. And that's one of the reasons many individuals who have litigation matters prefer to litigate them in the U.S. The good news about arbitrators in Florida is that you don't have to be a Florida lawyer to arbitrate. You can choose whatever lawyer you want, and under the Florida bar rules, if the private parties contract to have that particular lawyer be an arbitrator, you can do that through private arbitration. Now, there's pros and cons to private arbitration and litigation with a judge. You don't have to pay a judge in Florida to hear your case. They're paid by the state, and whether it takes the judge 6 months or 6 years, you're not on the clock with a trial court judge. With an arbitrator, it's different. If you have a private arbitrator and you get a good one, you're going to pay anywhere between $400 to $700 an hour. And that gets split between the parties, the litigants that are part of the arbitration. New York, Los Angeles, San Francisco, and the South Florida area are the 3 biggest venues for international arbitration. I'm partial to South Florida, not only because I'm a South Florida lawyer, I've also practiced in New York and California. In fact, I currently have 2 cases in California. The difference is that you get very good lawyers in South Florida for a lot less than what you pay in New York and in Los Angeles and San Francisco. I got a quick war story. I had a case in 2008 and 2009. One of my big developer clients asked me, Peter, go to New York, because the case was filed in the Southern District of New York, and there were companion cases in North Florida and in Miami. And my client said, go to New York and I want you to hire me the best lawyers in New York. And this is a developer that's pretty wealthy, but he's not Microsoft, he's not Facebook, he's an actual human being with a wife and kids, and he's got a small business, but he's a wealthy guy. And I told him, are you sure you want me to get the best lawyer in New York, or the best law firm in New York? And he goes, yep, it's not an issue. I got a $1.5 million budget for this case for the New York lawyers. And sadly, he had a smaller budget for me and my firm. But we went to New York, my partner Roland and I. We met with 6 or 7 law firms, and we picked the best law firm that will remain nameless for purposes of this discussion. And in 5.5 months, they billed my client $2.9 million. They blew through the $1.5 million budget. My firm billed $700,000. And that's another sad part to the story. So, you know, the quality of the legal work was on par with the New York firm, but they have a much higher overhead. They have a bunch of taxes in the city of New York that you don't have in Miami. And that's something that you have to consider for folks that are doing business. You know, you have a budget, and your budget's going to get blown out of the water out west or in New York, where in Miami, the hourly rates for quality, seasoned lawyers tends to be less than their counterparts in New York and in Los Angeles. The good news about that story is that that client has never complained about my bills ever since we resolved his case very favorably. So that's something to consider. Miami also has the benefit where, like I mentioned, a lot of the partners in my firm, excuse me, are kids of Cuban immigrants, Cuban exiles. So we're fully bicultural, we're fully bilingual, and that's important because a lot of the clients that we represent from Latin America, they speak English. I mean, I represent a lot of folks from Venezuela, and most of them speak perfect English, but they prefer to speak Spanish. They want to go have un cafecito. They want to be able to deal with somebody where culturally they can have a connection. And that's something that abounds in Miami. You have, you know, tens of thousands of lawyers, whether they're Cuban American or from Colombia or exiles from Venezuela, that can accommodate the needs of Latin American clients that are looking to litigate their disputes here in a legal system where they can actually rely on the rule of law and where judgments are respected. Now, the law in Florida is clear that if you are a company in Peru and a company in Argentina and you enter into a contract, just because you put a contract provision that says venue will be in Miami-Dade County and Florida law will apply, that alone doesn't work. Miami has plenty of litigation. They're not welcoming a lot more just because you have a contract provision that says that. In order to be able to have the court accept the jurisdiction of any dispute, there has to be some sort of substantial connection or business with the venue, or there has to be a wrongful act that was committed in the venue, or there's case law that says if you have to be paid funds, and those funds were supposed to be paid, delivered, wired, in Miami-Dade County, then, or in South Florida, then you can get venue, and you can also have a choice of law. So those are provisions that are important because when you're doing these contracts and you want to have venue or you want to have Florida law apply, you have to make sure that not only do you include the proper provisions in the contract, but you have to structure the transaction so you have a relationship with the form, with the venue that you're selecting as part of the venue selection provision in your agreement. Pablo went into my partner Pablo, about the real estate, the job market, the economy here in Florida. Litigation accounts for more than half of the expected growth in law firms in the United States. There's been in every single poll or survey that's been done with law firms in the U.S., 52% of U.S.-based lawyers surveyed expect litigation practice to be the top driver of the job growth in the legal market, followed by general business and commercial law and real estate law. So if you're in business, sooner or later, you're going to end up having a dispute. And if you can't mediate the dispute, you're going to end up either in arbitration or in litigation. And I've given you some of the variables and factors you should consider weighing the option between private arbitration and litigation. Thank you very much for your time, and I'm happy to talk to you during the happy hour. Thank you.